So this just dropped yesterday. We finally have Ross's reply brief in their appeal against Thomson Reuters in this famous case that all the anti-AI people are all gaga about because it proves AI is theft. And this is the one, if you remember before we covered this, the judge specifically said that Ross is not a generative AI. And so the claim is that Ross copied Westlaw's Headnotes to make an infringing product. They're not creating anything new. They're just grabbing what the AI has trained on West's intellectual property and passed it on to the user. Ross is telling a different story, and it's a good one, and we're seeing a lot of this. And again, I'm not going to go through the whole thing. It's 43 pages. We'll just hit a few of them. But it probably will apply to generative AI cases if the appeal goes a certain way, just not in the way the anti-AI people wanted to. Because as Ross is going to argue here, you have things that work a certain fundamental way that make them fair use. And that is the case with both Ross's AI and ChatGPT or whatever. And so Ross isn't a generative AI because it's not making a creative output. It's not trying to explain things in its own words, which also means it can't hallucinate, which is good. Because we've seen the problem when people use ChatGPT to write a legal brief and it just makes up cases that don't exist, and then the judges don't like that. That's not a problem in and of itself. You just have to double check everything ChatGPT gives you, make sure the cases are valid. And it's the fact they didn't do that the judges didn't like it. But here they're pulling no punches. We're going to start here on page 7 of the PDF document, which is the first page of their reply, where they start off saying, West's answering brief is a hallucination. That's hilarious. Yep, because Ross is a generative AI. It doesn't hallucinate. West is hallucinating. West sued because Ross's transformative AI legal search platform interfered with its profits from owning the law. For the past century, West has pursued monopoly and ignored copyright law's purpose. Yeah, you talk to lawyers, they'll say, Westlaw is your only resource. And so how dare Ross compete with them? West wonders why on earth anyone would pay for its platform if others can use Headnotes to build transformative technologies. This court should offer a reminder. Copyrights are not get-out-of-competition free cards. That's important. I'm going to say that again. Copyrights are not get-out-of-competition free cards. They reward creativity and scientific advancements. Remember, it's not to make people rich. It's not to let them profit from their products or their creative output or whatever. It's to promote the progress of science and useful arts. I guess we kind of need to be constantly reminded of that. So on the next page, they talk about one we've talked about, Feist v. Rural. This is the one where the telephone company sued because people who were making a regional telephone book grabbed all their information, included in and sorted it in with it. And the Supreme Court said, nuh-uh, you don't have anything creative in there. Therefore, it's nothing you can copyright. And they say West's Headnotes are the same way. They replicate judicial opinions as closely as possible. West's sample Headnote proves it, and we'll look at that in a minute. The Headnote parrots the opinion and includes no copyrightable expression. West's alternative argument, it can copyright pairings of individual Headnotes and case passages, also fails. West cannot copyright its selection of a Headnote any more than the Headnote itself. West's assertion that Ross was a market substitute for Westlaw finds no support in copyright law, the record, or economic theory. Ross was an innovative startup that did not replace Headnotes, the original work, and West's copyright does not allow it to monopolize the market for legal research platforms. In any event, there is no evidence that Ross hurt market demand for Westlaw. As for West's theory that Ross harmed its ability to license its Headnotes as training data, courts have repeatedly rejected that circular argument, and they'll get more into how circular it is. So the Headnotes are key here, and they point out that West's Headnotes either do not deviate from the judicial opinion or deviate trivially. None are creative, none are copyrightable. And we'll see that over here on page 14. We've got West's sample Headnote from the case Seymour v. Richardson. And you see they've highlighted the parts they've taken from Seymour. Seymour said, a cause of action is said to accrue to any person when that person first comes to a right to bring an action A right of action is the right to bring suit in a case. The cause of action means the act or omission constituting the violation of duty complained of. West's Headnotes says, a cause of action accrues to a person when that person first comes to a right to bring action, and then their original part is, and consists of, act or omission constituting violation of duty, and then West inserts, but differs from a right of action, and they insert which is the right to bring suit. So they just compressed it and they did a little bit of rewording. The Headnotes substance is copied from Seymour. The editor's additions in green are garden variety or obvious. The Headnote fails Feist's test. It was copied from the opinion, not independently created by the editor. And for another example, they use another case we've talked about, New York Times v. Sullivan. And here we're not only looking at Sullivan, we're looking at Lexis as well, and then we'll see how Westlaw differs from Lexis that makes them oh so creative. So in Sullivan, the court said, thus we consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Lexis just summarized that as, debate on public issues should be uninhibited, robust, and wide open, etc., etc. Westlaw's original change was in changing that first clause there in green to, there is a national commitment to principle that debate on public issues should be uninhibited, robust, and wide open, etc., etc. So you see, there's nothing really creative there. Lexis copies from Sullivan verbatim, and West essentially does too. West's additions, there is a, are obvious, garden variety, or routine, and show that a competitor would have difficulty creating an alternative without using many of the same words. There is a, there has been a, we know there is a, or whatever. There aren't many ways you can compress that, and they chose pretty much the most obvious one. And so over on page 16, they also bring up merger, and we've talked about that before. Copyright is based off the idea-expression dichotomy. You cannot copyright ideas. You can only copyright expressions of those ideas. If someone else comes up with a different expression of your idea, you don't have a copyright over that. Well, merger is where the idea and the expression are so inextricably linked that even the expression becomes something you cannot own, and anyone else can use that expression, and that's what they're talking about here. Because West cannot dispute that its editors must follow the court's language, merger separately defeats any claim to copyrightability. Because if you deviate from the passage, then you change the meaning of that passage in potentially misleading ways. You need to keep that language the same so that you don't mislead your users. And that is so important in the law. There are only so many ways to recite a legal holding. West, like the district court, argues Headnotes could be worded in a number of different ways. Both ignore that merger forbids copyrighting future use of the substance, here the law. So they cannot copyright future use of the law. And the only thing in their Headnotes is the law. Therefore, they can't copyright it. All right, then on page 19, we get to training. Ross advanced science by building an AI search engine that made a new form of legal research possible. In so doing, Ross used a tiny fraction of West Headnotes. This is a fair use under a straightforward application of settled copyright law. So even if you want to say there's some sort of minuscule copyright there, it's fair use. Headnotes are functional works far from copyright's core. Ross's use of West's Headnotes facilitated radical technological advances by using deep learning techniques that trained its search engine to understand and answer a legal researcher's question. Ross's use of Headnotes is an example of intermediate copying, which scores of cases recognize as transformative. You can do the intermediate copying as long as you don't pass those copies on to the user. That's where it becomes infringing. West disputes neither point, nor can it point to a case that holds commercialism outweighs transformation, where, as here, a new technological work does not produce the original work. Offering a new method of legal research that changed both the function and the user experience comfortably fits in a long line of precedent supporting transformative use. Indeed, every use of an original work to build a new technological platform that does not involve reproducing the copyrighted work has been deemed transformative. West cannot identify a single case suggesting otherwise. It doesn't matter if it's AI or what, even if you just made the intermediate copies for research purposes, as long as you don't pass it on to the user, it's transformative. You change enough so that none of the expression is there, it's fair use. West also does not dispute that Ross's use is fundamentally the same as what Cadre and Bartz deemed exceedingly and spectacularly transformative. And here's the part that made me sit up and take notice, and the real reason why I wanted to do this video, because it's so important. West tries to distinguish Cadre and Bartz by claiming this case does not involve generative AI, even though it publicly described Ross as generative AI. Okay, yeah, West, so which is it? As far as court's concerned, you're going to say, oh, no, it's not generative AI. Then you win in the district court, and you start going, see, we took down generative AI. But Ross says this distinction is irrelevant because the generative AI label is technologically meaningless. You're getting some information, and you're doing machine learning on it, and you're training an AI. The only difference between this and a generative AI is what you're having the output do. So with ChatGPT, you're trying to create novel output that's creative. With Ross, you're just trying to be like a search engine, giving search results. This is actually brilliant, because it points out that there is no magic switch that could turn AI training from being non-generative to generative or whatever. It's such a gray area, and it would be a really bad thing if companies could evade liability just by calling their product generative or not. And then so much of the briefs back and forth would be, yes, it's generative. No, it's not. Yes, it is. No, it's not. Yes, it is. No, it's not. The fact is, as Ross points out here, all of the same legal issues apply. How they're trained, the fact that no copyrighted works are stored in the model, none are received by the user. All of that is the same between Ross's non-generative AI and generative AIs like ChatGPT. It's all the same. It's all fair use. And I think that makes their point here on page 27 all the stronger. Trying to rehabilitate the district court's error, West offers two unremarkable points. Sega and Sony are out-of-circuit cases, so I guess they want a circuit split? And two, intermediate or not, the key consideration is whether the use was transformative. Neither point moves the needle. West suggests that the intermediate copying cases do not apply because Ross did not disassemble a computer program to access its underlying ideas or functionality, like in the Connectix case. We talked about that before. But Ross did far more than its predecessors. Ross disassembled language to learn the relationship between words. In so doing, Ross removed the actual expression of text to create a computer code. The prior transformative uses made new code from old code. And that's fundamentally what's important. That's why Ross is fair use. That's why ChatGPT is fair use. That's why it's all fair use. Of course, we know their real problem with it is they compete with us. Well, West complains about competition, specifically Ross offering a commercial substitute of Westlaw with the unrebutted goal of taking its market share. Ross's subjective intent is irrelevant. Warhol, for example, does not discuss intent at all, so not even Warhol is helping them. And Google, and they're talking about Oracle v. Google, was skeptical about whether bad faith has any role in a fair use analysis. Instead, commerciality is an objective inquiry that focuses on the specific use of the copyrighted work rather than the user's financial ambitions or business plans. And this is a mic drop here. This is the one I had to share on social media as soon as I saw it. Because they're all like, you harmed our market. And Ross is going to say, what market? West concedes that there is no market for Headnotes as independent search tools. So neither the legal memos, the allegedly infringing work and challenged use, nor Ross bring a competing substitute for the original or its derivative to the marketplace. West provides not a single case that ignores the absence of a market for the copyrighted work. That ends the matter. But Westlaw's another misdirection. Ross harmed the market for Westlaw, and Westlaw's content value as training data. This argument threatens to transform copyright protection into business model protection. Yes! That's what they've been trying to do for over 20 years. That's what the DMCA is really all about. That's what these anti-AI cases are all about. They have been trying all of this time to use copyright to make their obsolete business models profitable. That's the only reason. In any event, Ross did not copy West's outdated platform. Nice little jab there. It produced judicial opinions, not Headnotes or Westlaw content, and had no equivalent to the key number system. Your old obsolete key number system, your outdated platform. They're doing that Men in Black thing, where he was like, old and busted, new hotness. That's what they're saying. West is old and busted. Ross is the new hotness. This argument protects West's business model, not its allegedly original works. So if Westlaw users ultimately left for Ross, they did so because Ross introduced a wholly new product. Any resulting competition is one of copyright's virtues, not a vice. That's what we want to allow. We want to allow new competition to enter the field. All right, not too much left to go. I'm up here on page 34. This is where they get into that circular argument I mentioned. West argues that Ross harmed the market for Westlaw content as AI training material. This argument is circular. It is a given in every fair use case that plaintiff suffers a loss of a potential market if that potential is defined as the theoretical market for licensing the very use at bar. But West's expert did not identify a single company that specializes in legal training data that includes copyrighted works. Existence of AI platforms is not proof of a market for Headnotes as training data either. They're just trying to say just because you exist, now there's a market for us and you violated it. Even though that didn't exist before you did. And this next one here on 37, I think is like, well, we already kind of had several other nails in the coffin. This has got to be the final one. Ross is an entirely new product. That's why West provides no evidence that Ross caused a meaningful or significant effect on Westlaw content's market value. Indeed, customers purchased Ross and Westlaw. Some preferred Ross, but still needed Westlaw's case summaries, headnotes, or comprehensive repository of secondary sources. And to me, that clinches it. It's not a market substitute if people buy both. The whole point of a market substitute is that now they've bought theirs, they're not going to buy yours. But we've got people buying both because they're finding different values in Ross's AI than they are in Westlaw. And here's the thing about it. Courts are not supposed to be there to protect business models, but they kind of are. The Connectix case was there because they threatened hardware lock-in. Ross is there because they threatened Thomson Reuters and their subscription margins. That's what this is all about. Harming the market as in harming their business model, not as in making an infringing substitute. So that's why this case matters far beyond Ross, even beyond AI, and this appeal actually matters. Intermediate training copies are either fair use or they aren't. That cannot depend on whether the system ends up writing sentences or retrieves passages from an existing repository like all of the legal decisions. In Connectix, that copying was functional, non-expressive, and not retained in the outputs. That's all the court needs to follow here. Generative AI is more about the interface and how it deals with the user than how it was created or what the model actually is. And if they go against that here, they can go against any intermediate copying for any other purpose, and fair use is dead. That's the fight we're fighting. That's why I'm making these videos. And if you want to help me keep making them, then comments for the comment god, shares for the share-a-throne. Sharing does a lot, you know. as well as hitting like, subscribe, and the bell. And of course, donate.bogosity.tv to keep me doing this, whether with one-time donations or regular support. So thank you so very much for watching. I hope the rest of your holidays are great, and until next time, stay strong and be free.